morning, and thank you for joining us. My name is Kelly LeGrand Wiener, and I'm the managing attorney at Scott Legal. We're going to spend some time today talking about the National Interest Waiver Green Card, also known as the NIW. This is an underutilized category and one that we've started to see more and more people use to get a green card, in particular in the entrepreneur category. A few things before we get started. Scott Legal is a full-service immigration firm, and we offer a number of different types of visas, including visas in the NIW category. We will continue our webinar series, doing at least 2 webinars a month on different topics. At the end of this webinar, we will send out a few things to you. One is the PowerPoint that you'll see today. Another is a comprehensive guide to the NIW. And the last is a link where you can sign up for additional webinars. In terms of our panelists today, we're very lucky to have our associate, Jie Wang, who's a very experienced attorney who has significant experience in the extraordinary ability category and NIWs. As I said, my name is Kelly LeGrand Wiener. I'm the managing attorney at Scott Legal, and I'll also be presenting. If you have questions as the webinar goes on, please send your questions to the chat box. We will make some time at the end to answer any questions. So without further delay, we will get started. First, let's talk about the National Interest Waiver requirements. So the National Interest Waiver is a green card that is offered under the EB2 category. This means that there's a threshold requirement of either an advanced degree, meaning a master's degree or higher, or its equivalent, meaning a bachelor's degree plus 5 years of post-baccalaureate progressive work experience in the relevant profession. Or if you don't have the degree, then you can qualify based on exceptional ability. Exceptional ability, you have to meet at least 3 of 7 criteria. They're all listed here. I won't read them all out, but you can take a look at them and review them later. Exceptional ability is defined as a degree of expertise significantly above that ordinarily encountered in the sciences, arts, or business. This exceptional ability is a bit different than the term extraordinary ability that we hear for other types of green cards like the EB1A or the O1 visa. Exceptional ability is a lower standard than extraordinary ability. However, both exceptional and extraordinary ability go through a 2-part test where USCIS will first evaluate whether the evidence meets the regulatory criteria, and then will evaluate the quality of the evidence in a holistic sense. So for example, being a member of a professional association satisfies the criteria from a regulatory standpoint, but in the second part of the analysis, the officer is going to consider whether that membership indicates the person has a degree of expertise significantly above that ordinarily encountered. So it's not enough to just be a member of a professional association. You also have to meet that second part of the test to show that really that exceptional ability is demonstrated through that membership. So once you've met one of these threshold criteria for the EB2, then we turn to the National Interest Waiver. Under a kind of a normal EB2, at this stage, you would test the labor market. You would need an employer, and the employer would have to test the labor market to determine if there are any willing, qualified, and available U.S. workers for the job. Under the National Interest Waiver, what you're doing is you're asking the government to waive that requirement of a job offer and to waive the requirement of the labor certification. And to do that, you have to prove 3 prongs. So one is prove that your proposed endeavor has substantial merit and national importance. You have to prove you are well positioned to advance this proposed endeavor. And then you want there to be a showing on balance it's beneficial to the U.S. to waive these normal requirements of a job offer and a labor certification. And we'll talk about each of these in a little more detail later on, as well as going through some of the kind of case studies of what might qualify to kind of very briefly go over more on these particular prongs. We take the example of an engineer who was going to run a consulting firm in technology management and workplace consulting. And this person had developed a patent to help small and mid-sized businesses automate and optimize profitability without losing any jobs. So there was an ability to retrain and redefine workforce to prevent US job loss. So when we look at the substantial merit and national importance prong, the arguments were that there's substantial merit and national importance to preventing job loss and providing companies with a way to stay competitive while not displacing workers. Additionally, hiring U.S. workers, having both, substantial merit and national importance. Here, the patent and the 5-year business plan showing how the person would be able to accomplish this were very important. When we talk about the well-positioned to advance the proposed endeavor prong, this person had 30 to 40 years of experience in relevant jobs. They had letters from, former supervisors, from colleagues, as well as experts and people in the industry that were interested in partnering with this person for their new business. So all of that helped meet that prong. In terms of the last prong, showing on balance, it's beneficial to the U.S. to waive the requirements of the job offer and labor certification. One argument that's good for entrepreneurs is you can explain it's impractical to get the labor certification because of the ownership of the company. So the labor certification process is not set up for entrepreneurs who own 100% or a majority of their business. It's just not going to be approved because the government would not believe there's really a bona fide job opportunity open to U.S. workers. So that's one argument you can use. Another is you could explain that having someone this experienced working on this important issue of preventing job loss and worker displacement was beneficial to the U.S., even if there are other qualified workers working on this. So the issues are urgent enough that it's, we want to have as many people as possible working on this. So let's talk a little bit about how the national interest waiver can be used for entrepreneurs. So in matter of Danazar, which was decided a few years ago, there was a lot of really friendly language for entrepreneurs, and the standard for the national interest waiver was essentially rewritten in this case. So a few different things that were particularly helpful to entrepreneurs. One was the court explained that the benefit to the U.S. interest can be local, meaning that hiring employees in a local area could satisfy substantial merit and national importance. So you don't have to show that your endeavor is going to necessarily cover a large geographic scope. It can qualify, for example, if you are employing workers in an economically depressed area, that can still have substantial merit, that can still have national importance, even though it's, geographically, it's only focused on one particular area. Another area that's good for entrepreneurs that was really spelled out in Danazar is that they're self-employed, often not eligible for green cards under the labor certification. So they can use this fact that it's essentially impossible to obtain a green card through labor certification without, company to show that on balance, it's beneficial to waive the requirement of the job offer and the labor certification. Another thing that's helpful for entrepreneurs was that Danazar noted that entrepreneurial work can lead to an NIW and that the planned venture does not need to ultimately succeed as long as the applicant can show that more likely than not it's going to succeed. So you don't have to have a common question is people ask, do I already have to have a successful company to qualify for the NIW? So, and the answer is no, it is possible to apply with a brand new startup. In Danazar, that's part of this language is they explicitly acknowledge many entrepreneurial ventures fail. You don't have to prove that it's absolutely going to succeed, but you need to show more likely than not that it will, and that you're well positioned to advance your endeavor. That being said, even though you can apply with a pure startup, you do want to show that you, the applicant, have successfully brought similar types of businesses, into a kind of successful completion. Whether you, started the business and then you sold it for a high dollar value, or whether you just have endeavors over time that you have worked on and then left, but they have a track record of success. So that is very important to kind of meet the second prong. In terms of, people will also ask, what are the pros and cons of applying with an established company versus a startup? So if you have an established company and it's very successful, obviously this is going to be helpful to show you're well positioned to advance this endeavor because you have successfully advanced the endeavor. However, if you have this business and the company is actually not doing very well, then you're going to have a harder time than if you had, for example, a startup where you can rely more on a business plan and projections of how the company, will do. So it really depends, kind of on the particular situation of the company, but both an established company and a startup can potentially work, for the NIW. So let's move to talk about kind of timing and considerations when you are moving from a non-immigrant visa to, to a green card or to the NIW. So at this particular point in time, there's no premium processing available for the National Interest Waiver. This means the I-140, once you file it, could be pending for several months, even upwards of a year. We do expect this to change in the near future. There has been, there have been kind of reports that USCIS is going to add the National Interest Waiver to the premium processing list, which would mean you could get a response within 15 calendar days after you pay a fee of $2,500. However, this hasn't happened yet. So as of right now, the National Interest Waiver, when you file it, there is no ability to premium process, so it could be pending for a very long time. If you're on a non-immigrant visa that doesn't allow for dual intent, so the TN is an example of this, the F1, the E visas, you want to just be cognizant that when you file the I-140, it may be more difficult to renew your visa. So if you have a TN and it's about to expire and your employer wants you to continue working, you may want to renew the TN before you actually go and file the I-140, because having an immigrant petition pending is something that can weigh against your argument that you actually have non-immigrant intent, that you don't intend to settle in the US. In terms of the actual application process, you submit your I-140 with all the proof that you meet the EB2 qualifications, so that those threshold requirements we talked about. And then you also need to include proof that you qualify for the National Interest Waiver. So all the documents that would be included to talk about why you meet each of the three prongs, and outlining the substantial merit and national importance of your endeavor. Background information about you to show that you're well positioned to advance the endeavor, and then your arguments as to why it's beneficial to waive the the job offer and labor certification requirements. If you're in the U.S. In a valid status, for example, let's say you're here on an E2 visa, and there's an immigrant visa available to you, then you could choose to concurrently file your I-140 and your I-485, your green card petition, at the same time. You may also choose to just file your I-140 and mark it for consular processing. That in that case, once the I-140 is approved, the approval will be transferred to the U.S. consulate in your home country, where you live or where you most recently resided outside the U.S., and you'll go through the green card process at the U.S. consulate abroad. In terms of kind of the pros and cons of adjusting in the U.S. versus consular processing, it's going to depend, for each person. However, if you're in the United States, you and your family live here, maybe you're on for example, an E1 or an E2 work visa, you're on an H-1B visa, something like that, and you're all established here, your kids are going to school, your spouse is working or is here in the US, then likely you're going to want to adjust status. That is the process that allows you to stay in the United States during the whole green card process. It does mean that once you file your green card petition, unless you're on an H or an L visa, you will have to wait in the US. You can't travel internationally until you get your travel authorization permission, which can take a few months. So like for somebody who needs to travel internationally frequently, who cannot stay in the US for that period of time, or for someone who doesn't have underlying status and is just outside the US, maybe used to live here, but now lives outside the US, or has never lived here, but wants to. For those people, consular processing is going to be, the process that they'll likely follow. Filing the I-140 by itself doesn't give you any status in the United States. So like, for example, let's say you came here on an ESTA and you're doing some background things for your business as a business visitor. Just filing an I-140 doesn't give you any status, and there's no ability to kind of stay here based on that. So you would, kind of need to file your I-140, but then consular process in order to get your green card. And one thing so other people ask is if family members can apply for the green card with the main applicant, and the answer is yes. Your spouse and your children who are under 21 and unmarried can apply for the green card part of the application with you. So I will turn it over now to GA.
Great, thanks, Kelly. So what is included in an NIW submission? So let's sort of go over the documents you want to make sure that you include when preparing for your petition. So it is important to realize that the NIW is a very paper-heavy application. So it is important to realize that the government will not simply take your word for the facts that we are arguing. So for example, if we are arguing that your work had this and that impact, the government will want to see some sort of documentary proof of that impact. If we are arguing that you have an advanced degree, the government will want to see the advanced degree. So let's start with what we would want to submit to prove the threshold issue to qualify under the EB2 category. So as Kelly mentioned before, you can meet this threshold in one out of two ways, either through an advanced degree or through showing that you meet 3 of the 7 criteria to show exceptional ability. Now, if you're meeting this criteria through advanced degree, you would want to show your diploma and in most cases, a transcript. And if your degree was from a foreign institute, you would want to also obtain and submit a degree equivalency report from an accredited institution so that it shows that your degree, that it is equivalent to a master's degree or above in the American context. Now, if you're meeting the advanced degree threshold through bachelor's degree plus progressive 5 years of work experience, in this case, you would want to include additional information documents. And your resume proving your 5 years work experience will likely not be enough. You will also need to get letters signed by your previous employers, talking in detail about what your duties were and how your duties changed over the years to get to more senior level, to have more supervision, to have more important duties that change as time goes on to show progressive work experience. Now, if you are meeting the threshold requirement through exceptional ability, meeting 3 out of 7 criteria, you would want to go through each criteria and make sure that you are including sufficient official documentary evidence that you meet each criteria. For example, one of the criteria that you can meet is 10 years of experience. Similar to what I just spoke about, if you are trying to prove that you have 10 years of experience in your field, you would want to get employer letters from all of the different positions that you've held in the past that will add up to 10 years of experience. And you'll want to make sure to calculate these dates so that they match up with the 10 years that we are arguing. Another criteria that a lot of people, that a lot of people rely on is memberships in professional associations. If you're relying on that criteria, you would certainly want to provide documentation of these memberships through ideally an official letter from the organization certifying your membership and that you are in good standing. And finally, if you are submitting, if you're meeting the criteria that you have a degree related to the area that you will be working, you would want to provide a copy of that degree, be it a diploma, associate's degree, what have you, and a transcript to show that you have taken coursework related to your area of exceptional ability. The second part of your petition will consist of documentation supporting that you meet all 3 prongs of the matter of Danazar test for an NIW application. So for example, an important part of your petition will be a detailed statement of your proposed endeavor. And that will be the basis on which USCIS will evaluate the substantial merit and national importance of your proposed endeavor. So it is very important to work with a lawyer or work on yourself to persuasively have this elevator speech and provide details that will allow USCIS to understand as they're reading it what exactly you're trying to achieve in the United States through your business. Maybe talk about the current gaps in the industry, technology, in the area that you're working, and how your business is proposing to solve these industry-wide problems. Now, in addition to your statement of proposed endeavor, you would also want to include as much proof as possible that the public or the government is interested in the area that you'll be working. And these could be in a variety of areas: agriculture, health, high technology, cybersecurity, semiconductors. And you could certainly do research and find news articles, journal articles, statistics, government reports, market reports that describe the public's general interest in advancing this field, or that the government has set up initiatives to advance the US competency in this field. So you would want to make sure that you have objective third-party evidence that back up your claim that the work that you are proposing to do is actually an area that there is substantial public interest in. So expert letters from experts could help in substantiating the national importance prong and also the well-positioned prong. So when you're submitting expert letters, it is also very important to include evidence of the expert's qualifications. So we usually include a full curriculum vitae, a CV, which persuasively shows any experience that they have, education that they have, publications that they authored, so that USCIS, when USCIS looks at it, it is clear that this expert is an authority in that area. And what that does is it makes the expert letter more persuasive and makes it more likely that USCIS will include that letter and the contents of that letter in its consideration. A strategy that could work well for entrepreneurs in particular is to work with an economist expert and have the economist write a report, basically looking at your business plan and analyzing your business plan and extrapolating from that business plan exactly how much the indirect and direct impacts of your endeavor will be. And this could go towards job creation. And this could go towards any secondary benefits coming from increased productivity. And we discussed earlier an example of someone who is developing technology to increase productivity of a business without involving job loss. In that case, how can we quantify those benefits in productivity? And retaining an economist to write an expert letter for you could really help bolster that claim of national importance, substantial merit. Another persuasive form of evidence that an entrepreneur can include in particular goes to proof of interest from potential clients, potential collaborators, potential investors in your enterprise. So you would like to get letters of interest from investors who would like to participate in your venture. You could get letters of interest from future clients, letters of interest for collaboration. And it does not need to be a long letter. It just needs to be a letter that describes the person's own credentials, describes how they know about your business and your credentials, and with a paragraph that says how him or her would like to work in future with your business. And these types of expert letters can go to both national importance and the well-positioned prong, because it shows that the community, business community in general, is interested in seeing your work succeed, which goes to substantial merit and national importance. And also it shows that you are well known as an entrepreneur in these circles, which can go towards showing that you are well positioned to advance your endeavor. Specific to the second prong, proving that you are well positioned indeed to advance your proposed endeavor, you would want to include a variety of evidences that go towards establishing your own merit and your own record of success in that field. And here you would include your resume, typically, any degrees, as we mentioned above, letters related to work experience, and importantly, what I advise a lot of clients to do is to include impacts of your past projects that you have done in a similar area of the endeavor that you are proposing to work in. And this is commonly done through letters of experts. And what we're looking for is evidence that your work has been shared with other experts in the field, be it through awards, patents, if you are called to speak at conferences, if you published any books that were sold, any evidence that those past endeavors were successful. You can also provide evidence of past contracts with household name companies if you have had those kinds of engagements, past records of investors investing a substantial amount in the enterprise. And these evidences are more powerful if those investors themselves are accredited investors or investors that have a track record of selecting meritorious businesses. And this could also go towards proving that you have the capital required to start your business or to continue operating your business. So the important thing to note about NIW petitions and preparing for the NIW petitions is that they are not cookie cutter petitions. They are usually very structured, very strategic, and well thought out. And organization of these evidences is very important so that the USCIS knows exactly what the strength of your petition is. Okay, can we go to the next slide now? Thank you. So now let's study a case where the National Interest Waiver was approved for an entrepreneur who was actually a consultant. And it is interesting to look at this case because actually this case was denied when it was first submitted, but the Administrative Appeals Board reversed the decision and actually changed the decision to an approval. So it is helpful because we can see the types of evidences that the Administrative Appeals Board looked at and felt that was helpful, which gives us a little bit more guidance on what kinds of evidence would be persuasive in your own case. So the applicant was a consultant who wanted to form a small consulting firm to work with a variety of organizations, giving advice, giving recommendations on how to improve services given to US veterans. And this person was a member of the veteran community himself and had spent more than 10 years working with a variety of organizations in designing these initiatives to improve services to veteran members, making bridges between the US and UK in different organizations to advance these initiatives. So for national importance and substantial merit, what was helpful was to submit letters that, well, not only letters, but also government reports, also research reports, journal articles that persuasively laid out that returning veterans have a difficult time and that there is a gap in the services provided to these veterans. The petitioner also included expert letters from senior officials in the military, government, business, and philanthropic organizations that also described this importance of providing effective programs for US veterans when they return home so that their transition to civilian life is facilitated. Finally, the petitioner submitted proof that the federal government has designed and operated initiatives to improve care for those who have served in the military. And providing evidence of such initiatives shows that the federal government really cares about this issue and is willing to spend money on it and is willing to spend resources on it. So this was another persuasive piece of evidence that went to national importance and substantial merit of the proposed endeavor. To prove that this petitioner was well positioned to advance this endeavor, also a variety of evidences were included. A very important piece of evidence in this case was expert letters from people who had previously worked with this petitioner. So in these letters, there were detailed descriptions on how the petitioner's work enabled organization A or organization B to successfully initiate and operate this particular program. And there were multiple testimonies of such successful, impactful examples of his work. And this went through to really describe the petitioner's expertise and record of success in similar endeavors, which the USCIS found very persuasive. Regarding the petitioner's plans for his future work as a consultant, the petitioner submitted a business plan for the proposed company, including the details about the types of services he would provide. And importantly, he also submitted letters from potential clients who was interested in working with this company, and also included financial statements which demonstrated that he had sufficient funds and investments to cover the startup costs of the company, which went towards the petitioner being well positioned to actually bring this venture to fruition. Finally, on the third prong, that on balance, it was beneficial for the US to waive the requirement of the job offer and labor certification, the Administrative Appeals Office talked about how for entrepreneurs, it is not practicable to use the labor certification program because the entrepreneur has ownership in the company. The Administrative Appeals Board also really emphasized the exceptional benefits that this venture could bring in terms of national importance, substantial merit, and also how this person is exceedingly well positioned to advance the endeavor given his decades of experience and testimonies of the high impact of his work that he has persuasively demonstrated through the expert letters. Okay, so now I think we can go on to questions and answers.
It doesn't look like we have any questions. So thank you so much, GA, for it looks like someone raised their hand, but if you have a question, please add it through the chat box.
Yes, happy to answer any questions you may have. We can give a minute to see if any comes in. I am an international student.
Okay.
Can I obtain an LLC?
Yeah, so yes, it's possible to own a business in the United States, including opening an LLC while you don't have work authorization, but you cannot work at that company. So yes, it's possible. So yes, you can start an LLC. You can potentially apply for the NIW, but you can't work at your company until you would get work authorization.
Yeah, totally agreed. And it will be important to bring in any of your past endeavors to really persuasively show like how you are well positioned to sort of hit the ground running with this company, if that is your plan to apply right after your academic program is ended.
Perfect. Well, that looks like all the questions we have. Thank you so much, GA, for sharing your knowledge, and thank you everyone for attending. I hope everybody has a great day.